Hey, deputy, bring her back in here. Deputy.
Yeah. What is it?
You have something you want to say to me?
Not you. No. No, sir.
You were in my courtroom. I
was walking away from your courtroom is what I was doing.
Ma'am?
I am so tired of this system fucking me over. Is what I'm tired of doing.
25 CR 43210, the state of Ohio versus Rebecca Curtis. You are Rebecca Curtis?
Yes, sir.
Ms. Nicholson is here on behalf of the state of Ohio. Can you tell me when she's scheduled to be in front of grand jury?
Her indictment was issued this morning.
She was indicted this morning.
So I do have a copy of that I can serve her with. It is for 2 counts of assault on a police officer, felonies of the 4th degree, the 1 count of obstructing official business, a felony of the 5th degree, a misdemeanor 1 resisting arrest, and a
The courtroom atmosphere shifted instantly when the judge ordered the deputy to bring Rebecca Curtis back after she walked out muttering frustration about the system. What followed was a tense exchange that set the tone for the hearing, as the judge made it clear that disrespectful language would not be tolerated in his courtroom. Curtis insisted her anger was not directed at the judge personally, but toward the justice system as a whole. Despite her attempt to clarify, the judge viewed her comments as inappropriate courtroom conduct. The moment highlighted how quickly emotions can escalate when defendants feel unheard or mistreated. From the start, it was clear this hearing would be anything but routine.
Misdemeanor 4 criminal trespass.
Okay.
For the record, she has been handed a copy.
Thank you.
And Your Honor, we do have an arraignment entry if the court wants to arraign her today.
No.
Or it's set for next week.
Yeah, she can just wait.
Okay.
It's she was just served, so she's got 24 hours. She might as well just set it for next week. Ms. Curtis, it's somewhat unusual for me to schedule this for hearing. Since I did not set your bond, I did not revoke your bond. Usually I only set these for hearing if I revoked your bond from the lower court. Tell me why I should modify this bond.
Well, I'm just trying to be home for the holidays, really. If I can.
Officer, you have any information about this at all?
You're hooked into the jail on the 25th. She'll have 25 days credit. I spoke with her over the phone yesterday and put all that information in the bond report. She provided a Middletown address. She reported.
The state formally announced that Rebecca Curtis had been indicted earlier that morning on multiple charges, including 2 felony count of assault on a police officer, obstruction of official business, and additional misdemeanor offenses. The court confirmed she was properly served with the indictment and discussed whether an arraignment should proceed immediately or be scheduled later. Given the timing, the judge chose to set the arraignment for the following week. The discussion then shifted to bond, with the judge noting it was unusual for him to review it, since he had not originally set or revoked it. Curtis requested bond modification, so she could be home for the holidays, prompting deeper scrutiny of her background.
She stays there a few days off and on, and then goes and stays at motels often. Reported she's not employed, that she's unable to get employment due to having cirrhosis and her mental health. And then she reported that she's currently in treatment with Butler Behavioral Health for PTSD, battered woman syndrome, human trafficking victim, but I was unable to verify that.
Got quite the record, Miss Curtis. Dating all the way back to 2008. I'm sorry. Goes on. I'm sorry. What keeps going on? 2002. Who do you live with?
My daughter.
The state have a request for bond.
Your Honor, this occurred all 75 back in November. So I don't know if it appeared that she was living there at the time. You know, I know I read in her letter that it indicated that she was in treatment, but alarming that this set of facts occurs while she is in treatment. Additionally, she was sentenced to prison in January for an after an ILC violation, and was released about 4 months prior to this offense. She has a history of community control violations and not following orders given to her by the court. So I think if the court is inclined to release her, her bond is $100,000, 10%. If the court is inclined to modify that or to release her, we would ask that she be placed on electronically monitored house arrest. It sounds like she doesn't.
As bond was discussed, the court reviewed Curtis's unstable living situation, lack of employment, and claims of medical and mental health treatment that could not be verified. The judge pointed out her lengthy criminal history dating back more than 2 decades, along with prior community control violations. The state emphasized concerns about her recent release from prison and repeated failures to follow court orders. Prosecutors requested that if she were released, she be placed on electronic monitoring due to concerns over compliance. The judge questioned her credibility, especially given her refusal to attend court-ordered treatment in the past. The exchange painted a picture of ongoing legal trouble fueled by repeated poor decisions.
I don't know how stable her living arrangements are. She does have a lengthy history.
Ms. Curtis, you were granted ILC by me in December of 24, so 1 year ago. Within a few weeks of that, you refused to go to the CBCF that I ordered. So I'm guessing you just wanted to continue to use illegal drugs.
That's your assumption, but I can drop urine and it's clean. I go to.
Well, you've been in jail for the last 30 days. I certainly hope that you'll be clean.
Oh yes, but I'm saying prior to that, you can discuss it with behavior if you need to. I'm still going there.
Well, since you're going to be arraigned on Wednesday, at this point in time, the court's not going to modify the current bond order. I'll let the you can make a pitch to the magistrates when they arraign you next week. All right, that's all. Hey, deputy, bring her back in here. Deputy.
Yeah. What is it?
You have something you want to say to me?
Not you. No, sir.
You were in my courtroom. I was
walking away from your courtroom. Is what I was doing.
Ma'am?
I'm so tired of this system fucking me over. Is what I'm tired of doing. I really am, sir. It's not you directly. It's somebody else in this system. I appreciate you. I respect you. But I am not going to keep letting this shit happen to me. I'm not. And other people. It's not you. It's somebody else in this system. That's all I'm saying. No disrespect to you. Have a nice holiday.
I am disrespected because when you use that kind of language in my courtroom...
When I get mistreated by the system, you'd feel the same way, sir. Right. No disrespect to you personally.
But
it's somebody else. Okay. Thank you, sir. I have a freedom of speech, you know. Like I said, fuck 'em.
Curtis?
Yes, sir.
Ms. Nicholson is here on behalf of the state of Ohio. Can you tell me when she's scheduled to be in front of grand jury?
Her indictment was issued this morning.
She was indicted this morning.
So I do have a copy of that. I can...
Ultimately, the judge refused to modify the bond, stating that the matter would be more appropriately addressed at arraignment before a magistrate the following week. As the hearing concluded, Curtis once again expressed frustration, claiming the system continued to mistreat her while insisting she meant no disrespect toward the judge personally. The judge firmly responded that such language in the courtroom was unacceptable regardless of intent. Curtis invoked freedom of speech, while the judge stood his ground on courtroom decorum. The hearing ended with unresolved tension, leaving Curtis in custody and facing serious charges with no immediate relief. The final exchange underscored how courtroom behavior can heavily influence judicial decisions.